A California court is hearing opening statements in what could prove to be a bellwether case for Meta and other social media companies.
29 U.S. states have sued the big tech giant. They argue Meta designed its platforms to be addictive, much like cigarettes. They say the company misled consumers by promoting its apps as safe while contributing to a youth mental health crisis. They accuse Meta of violating federal child privacy law by improperly collecting and using children's personal data. Now, a lawyer for the states described Meta's business model as being designed to hook the users, hold them for as long as they can, harvest their data, and hide the truth from the public.
And Meta rejects those claims. It says the states have failed to prove that its apps are harmful. The company says it's transparent with consumers and has put safeguards to protect young users. It points to the Instagram Teen Accounts feature, which makes data private by a default for users between the age of 13 and 17. And this restricts strangers from directly messaging them. But the states argue the safety tools are rarely used.
The stakes go far beyond Instagram. Meta also owns Facebook, WhatsApp, Messenger, and Threads. These apps are used by 3.6 billion people every day. Now, this case could reshape the way they operate.
Now, the states want Meta to eliminate likes count and the infinite scroll. They're also seeking close to $200 billion in damages. That's nearly 14% of Meta's market value.
Reports say the trial could last 6 to 8 weeks, during which the jurors will hear from Meta CEO Mark Zuckerberg and a whistleblower. A U.S. District Court judge will then decide if Meta is liable. If so, the court could impose penalties and order changes to the way Facebook and Instagram operate, and that could have ripple effects across the wider social media industry.
Now, we're joined by Vincent Joe Ralaman. He's a director of the Life Sciences Law and Policy Center at the Berkeley Center for Law and Technology. Well, thank you very much for joining us, Vincent. So, people are calling this social media's big tobacco moment. What sort of parallels are you seeing?
Yeah, the tobacco analogy is quite instructive, as is the opioid litigation that took place in America. In America, we have a paradigm that is very concerned with information asymmetries. And by that, I mean, you can sell to the public something that is addictive, that is very harmful for them, so long as the public knows that. And if the public doesn't know that, you need to add a warning label, or you need to have your public disclosures communicate that potential risk. And the argument here is about that deception. The plaintiff's attorney in the opening statements made this argument about the 4 H's, and the last one is hide. And that's going to be the key thing here. Did Meta know some information that was about their platform being potentially harmful, and did they hide that from the public?
Vincent, one thing that the big tobacco companies didn't have that social media companies have is Section 230, which shields apparently platforms from liability for third-party speech. So how are the states, going to show that this particular section, of that law doesn't actually apply now?
You saw Meta early on really trying to frame this as something that was about speech or getting very close to speech, and expect to see that more throughout this trial. The plaintiffs on the other side are going to say this has nothing to do with speech. This is totally independent of this. Their argument is going to be, you knew that your platform caused these harms, and those harms might be from other people's speech or from the way that it is designed. It doesn't really matter, because you knew that it caused this harm and you communicated something totally different to the public, meaning you deceived them. That is really the essence here. And that is why the Section 230 defense has not been successful thus far. And I don't think it's going to be successful in this case. And it's one of the reasons that this is one of the trials that I think there's been a lot of heavy guns put towards. They're not making arguments about the type of speech that is being posted on here by third parties. They're making arguments about the design of the platform and what Facebook knew and what they disclosed to the public. Those are separate arguments than speech.
Right. Vincent, just want to get into that a little bit. Many parents, I would dare say most parents, believe that social media is harmful for their kids. But we both know public sentiment isn't a legal standard. So what specifically, you talk about addiction, you talk about hiding the data. what specifically do you expect the states to do to present in court to show, that Meta actually put profits over the health of young users?
You're going to see a lot of information that was revealed either by whistleblowers. That's very similar to what happened in the opioid cases and the tobacco cases, or that has been revealed via discovery. And those are going to be internal presentations, internal emails, Slack communications, saying, hey, we know about XYZ risk. And then they're going to juxtapose that. They're going to timestamp those, and they're going to juxtapose that to say, what did Facebook say at that given moment to the public to try to find that disconnect? And to do that, they're going to, part of that is that argument's already been made. They've filed a lot of statements showing that, but they're also going to call a lot of witnesses to do that. On their own side, they're going to call a lot of the whistleblowers, which will be very interesting to see because those are people that used to work at Meta. But they're also going to call Adam Mosseri, the head of Instagram. They're going to call Mark Zuckerberg, the CEO of Meta, and they're going to say, hey, what did you know? Those will be very interesting things to watch to see what they knew at any given moment.
Yeah, specifically, some of the internal evidence sounds extraordinary. Employees reportedly refer to Instagram as a drug, themselves as pushers, while teen time spent was discussed as a goal. Just legally, how damaging is evidence like that?
That sort of evidence is really damaging. Meta's really facing two big trials right now. One is in court, in which they're facing, under their own terms, $1.4 trillion in potential damages. They might also have injunctive relief levied against them, meaning that the court might order them to change some element of their app, which could be really, really damaging. But on the other side, they're facing the court of public opinion right now. People are going to watch news reportings like this, and this is going to be all over the news for the next 6 weeks. By the way, it'll end in the United States on the next social media movie is going to come out, The Social Reckoning, which is the sequel to The Social Network, is going to come out right after that. This is going to be front of mind for a lot of people. And I think, honestly, the court of public opinion is going to be a bigger issue for Instagram or for Meta to overcome, because a lot of parents are going to look at this and say, I don't necessarily want to use this, and I definitely don't want my kids to use this. And that's going to cut off a lot of the user base for Instagram and Facebook moving forward.
Right, Vincent, Meta has already lost or settled 3 major cases this year. I'm wondering, how does all of this affect, this ongoing trial, for the jury, for Meta, for Mark Zuckerberg himself when he, takes the stand? Do you think they're going to try and settle?
I honestly was a little bit surprised that Meta did not settle on this. So originally there were 4 defendants. There was Meta, which stuck around, and Snapchat and TikTok and YouTube, and the other 3 had already settled. Now, to contextualize this, there was 2 earlier trials that are really instructive here. One took place in Los Angeles, and that was a bellwether case where an individual sued Meta to say, I was harmed. And that was one individual amongst at least 2,000 others, and that person got $6 million in damages. That was a really big settlement, or that was a really big verdict against them. But the day before that, New Mexico had a verdict that was originally $375 million. It then ballooned to over $900 million under their state unfair and deceptive practice statute. That unfair and deceptive practice is actually the key thing that is being litigated here. California, Colorado, Kentucky, and New Jersey are the first 4 that are going, but there's 25 others in just this trial alone that are going to come after them, all litigating against their own state's unfair and deceptive practice laws. That's the information asymmetry thing I was discussing, where did Facebook know something, and was that different than what they disclosed to the public? And New Mexico is successful in there, and I think that's going to be probably pretty instructive on whether or not these plaintiffs in this one will also be successful moving forward.
And Vincent, I'm curious, how every, consumer business wants customers to come back, but what could distinguish legitimate engagement from a product deliberately designed to exploit vulnerabilities, especially those of children?
Totally. And Facebook's going to make this argument, and it is a very reasonable argument, and it's going to be a huge uphill battle for the attorney generals to try to overcome. But the argument is going to be, hey, we know that on the far end of the spectrum, there are some people that had harms done to them. But we also know that on the other end of the spectrum, there's a lot of people that get a lot of benefits from social media. You can imagine people living in relatively rural areas with not a lot of access to people, or in extremely conservative areas where they maybe don't feel safe expressing their personal identities or their beliefs. And social media might actually provide a really valuable outlet for them. And expect Facebook to make the argument to say, hey, we knew about these things, but we knew that if we shut off access here to try to stem those potential issues, we would also shut off access on this side and we would end up kind of foreclosing a lot of really good things about social media. Expect them to hammer in that point. And frankly, it is legally in the United States a pretty legitimate point for them to make in the calculus of did they do enough to kind of potentially overcome these problematic use patterns.
And Vincent, just very quickly, because we have bans, social media bans, this part of the world, in Australia, I beg your pardon, and various degrees of restrictions in Asia and Europe as well. I'm wondering what the implications might be, for these bans, when we have a verdict here.
It's very difficult to get a full ban on social media in the United States. And one of the reasons is because the First Amendment, our Free Speech Act, is so significant in the United States. And any restriction that will potentially restrict people's ability to engage in speech online is going to undergo the highest level of scrutiny. And for that reason, I actually am somewhat skeptical if any legislation, any regulations or legislation from the government are going to be super successful. That being said, that's kind of why we're seeing the approach that we're seeing here, because it doesn't necessarily implicate speech or the First Amendment. What this implicates is this disconnect between what the social media platforms knew and what they communicated. That's actually somewhat independent of speech, but that First Amendment thing is a really big issue. And it's a reason that a lot of efforts to implement social media bans are at risk in the United States or have already been overdone. Just last week, France's social media ban was also undone for that same reason, because their highest court said this is potentially restricting speech, and it won't survive that level of scrutiny. So that's a really heavy thing for people to overcome. And it's also one reason why I'm skeptical that this trial will lead to any injunctive relief. Anything that the court will do to say, hey, Meta, you have to do X, Y, Z thing, and we're going to restrict your access, because that's the kind of thing that gets overturned. The fines or the damages for this deceptive practices is much more likely to survive. And the judge in this case, Judge Yvonne Gonzalez-Rogers, is not frequently overturned by the appellate courts. So I'm guessing she's going to probably get this right.
All right. Vincent, we have to leave it there. Appreciate you talking to us about this, that Meta trial ongoing right now, expected to last 6 to 8 weeks. Vincent Joelleman, Director of the Life Sciences Law and Policy Center at the Berkeley Center for Law and Technology. Thank you so much.